Welcome back to another episode of Upstate and Litigate. Today we're going to talk about depositions. I'm Derek Spada, here with my partners, Basch Keegan and Eli Basch.
Well, here we are again, Upstate and Litigate, and we're going to talk about depositions, which can be extremely important. They can either make or break a case, and we as the lawyers representing the plaintiffs, the ones bringing the case, help them get through the deposition and to prevail in the case.
Well, why are depositions so important, Eli?
Because the client gets to state under oath what happened. And if they get it wrong or don't recognize what their job is, or if they misstate, or sometimes even go a little farther than misstate, they can wreck a good case. And the purpose of deposition is not to make your case, but it's to make sure you don't break your case. And so it's really important. It's the time when the other lawyer gets to see you, evaluate you, ask you questions, and you get your opportunity to tell what happened.
Yeah, but people always get upset when they come in for a deposition. They think this is going to be their big moment. They're going to tell everything, and they're going to feel good at the end. And one of the things I always prep them and say, it is not our turn to talk. It is their turn to ask questions. And they want to know, what kind of witness are you? Are you the sort of person a jury's going to like? Or do you have a big chip on your shoulder? Or are you angry? Are you confused? It's important to try to get the testimony down correctly, not overstate your case, not understate it. Answer the question asked, because they know we've prepped you to say, don't go off on a tangent. You know how that happens?
Oh, yeah, I know.
20 minutes later,
you want to kick your client under the table. Yeah. There's people who you can ask them, what's your name? And then they go on for the next 15 minutes to explain, well, what happened was, and then, no.
12 pages of testimony after state your name and address for the record.
I think my record breaker was a client. They asked him his name 17 pages later in the transcript. Yeah. He was finished with what his name was.
Yeah, he couldn't stop talking.
He could talk. There's no question about that. But usually the defense lawyer knows more about your background, your medical treatment, past history, and what happened than you do. And it's not a memory contest. What it is it's an opportunity to present yourself as you are and to be careful. The lawyer is not your friend who's questioning you. The lawyer is your adversary and enemy. And what you do as a client is important. And what we as lawyers can do are very little, because we have to sit there almost like potted plants.
Right. Any objections that we would raise at court that might be sustained. I did a deposition yesterday, and I'm asking a witness this question, and she's just looking at me. And of course, we were on Zoom too, which is another whole thing we should talk about. And I said, is your screen frozen? Can you hear me? And she goes, no, there's an objection. And the defense attorney was just putting a routine objection on the record. It was not up to her to make the decision whether she could give an answer to the question or not, but she was deciding that she was going to try to be in charge. So it was a kind of funny episode we had yesterday. But the Zoom thing is totally different. Zoom is great in some ways and a nightmare in a lot of ways. You don't really get as good a feel of what the person looks like or how they're going to behave or how a jury's going to respond to them in person when you're on Zoom, because sometimes they're a little bit more staid, I think is the right term.
Yeah, it's made things much easier in some respects to do things virtually. Besides depositions, also going to court for conferences. When that's done virtually, you sit at your desk instead of traveling to court, waiting 20 or 30 minutes or longer for your case to be called. So it's helped in some ways. Things are more efficient, but there's been some personal touch lost there. Both with doing depositions and going to court. So I guess the end result is it's more efficient, but in some ways not as good.
Yeah, the flip side is sometimes it can project your client in best light, because there may be things that your client won't present well, that a Zoom deposition, just a headshot, helps us. The flip side is when you cross-examine a defendant. We also do depositions of the other party, of the defendants in lawsuits, and it's much more beneficial to us to have the opportunity to see the person physically and be in the same room. There are tics, things that you see in the person when you're questioning them live that you don't get in a Zoom deposition. To be in the room live with the person gives you the opportunity to really scrutinize the person. And sometimes just in the way they move their shoulder or their hands, maybe you should ask a couple more questions on that issue because they're holding back something. And in a Zoom deposition, you don't get to see that. You see a headshot. It's kind of antiseptic. And lawyers, us, Maureen and Derek, we're on the human side of things, not on the how would I say, the nitpicker, the...
Trying to trip them up. We're just trying to find out what kind of person this is.
We want the defendant to talk, to chat up. And the more they say, the better for us. And it gives us the opportunity. We lawyers are flexible. We just want to have the information, then we'll model it to our client's advantage. Flip side on the defense is that we want our clients to be very reluctant to offer up information.
Until we talk about damages.
That's it. I always say you can blab all you want. You complain to your lawyer, complain to the next door neighbor. What I want you to do is complain to the lawyer for the defendant about what your problems are. Don't be a hero.
And the defense attorney always knows to ask that question last after they've worn you down about what size of the pinhole it was when you tripped over it or whatever stupid way they're going to word questions. So the client just wants out of the room. They don't care what their answers are. And this is the most important part. We try to get them to pace. Take a break if you need it. You're talking about how we like to let the defense speak. I'm remembering a case where a deposition made a total turnaround on a case, and it was a medical malpractice case that I was prosecuting in Delhi, New York. And I had 8 men in the room because at that time there were very few women prosecuting cases at all as a plaintiff's lawyer, and the only other woman in the room was a court reporter. So I'm asking the key defendant, doctor, whatever. Now, my client, she had protein in her urine, she had a hypertension, she had this, she had like 5 of the classic 6 signs of preeclampsia. And I said to him, doctor, did you consider that the patient might have had preeclampsia and, needed to get admitted to the hospital? And he sat back and he said, oh, no, she didn't have that. I was like, what do you mean? How could it not be? Like, it's ridiculous. And all the guys are taking down notes. No, this doctor's right. And I go, well, what's your explanation? He goes, these white women in upstate New York get very fat when they're pregnant. And I almost fell out of my chair, and all the other guys are writing down fat women, upstate New York, and the court reporter and I are looking at each other, and I was like, they are not taking this case to trial. Thank you very much, Dr. Defendant. That was a great opportunity to do a good deposition just by asking plain questions. It was a lot of fun.
Yeah, there's times when the defense can volunteer information, changes the whole nature of the case, and things can fall in your lap. And other times your client can also talk too much and put their case in a hole, which is what we try to avoid. I've had cases go the other way as well, where you expect one thing and you get another. You expect the defendant to testify a certain way, and they may raise more issues. They may point to a new defendant where you have to start a new lawsuit, add more defendants to your case. But they can take a simple case and make it complicated. But you have to find these things out at a deposition. That way you don't get to trial and learn stuff at trial when it's too late. So
the question is that what you really want to do is go wide afield as a plaintiff to make sure there isn't anything in the bushes that you don't see, and they're going to spring it on you at trial. So you go through the normal questions, and then you try to go to a little bit more of the periphery of the accident, just to make sure there isn't something there that they're on the way to the veterinarian with their little puppy or something in the car, and it's just going to evince sympathy from the jury on some issue you wouldn't even ask. You may ask if there's anybody else in the car, but you might not ask, did you have a pet with you? But these things are on the total periphery, but sometimes they become important. And you just want to know about it so it doesn't get sprung at you at trial. And the defendants are pretty inventive, and most people don't fess up and say, we're sorry, and it's our fault. And you have to peel back the different layers and ask the questions. And if you do your job, you get ready for trial. And if you do your job well, there will be no trial. There'll be a settlement.
I do recall once a guy said, I hit him very hard in the rear. I hit them so hard. And I was like stunned. I didn't know what else to ask because he confessed, he admitted it, and he knew it was a high-speed rear-end collision. I was like, okay, I guess we're done. And it startled me. I didn't know what to do with that kind of information.
Yeah. The most important topics to cover at a deposition with your client are liability, which is how the accident happened, and also injuries. So there's all sorts of other topics that the defense lawyers will cover, like your educational background, where have you worked in the past, and they'll go on and on. Do you have any pets? Are you married?
Divorces,
kids?
income,
And
all personal things nobody really wants to talk about.
And it's all kind of relevant. I mean, they could skip those topics. They're borderline relevant, but the main reason why those are asked about, I think, is because most defense attorneys are paid by the hour, and they don't want to be done with this deposition in 20 minutes and say how the accident happened and what are your injuries. They want to, dig in and that's like
Take a
that's
break.
a major component. Yeah, take a break, like make a phone call. But secondarily, they also want to see how the client would come across to a jury. If the person has their life together and comes across as a likable person or not, because that's also a major factor, which we haven't covered in general on this podcast, but a major component in the value of a case is whether a jury is going to like your client or not. So if you have a client who's likable, that's almost half of the of winning at trial, and the other half seems to be the evidence.
Yeah, like they want to know who the former spouse was to see if there was an acrimonious divorce.
Right.
And meanwhile, even if there isn't a chance in the world they're going to bring an ex-spouse to trial to testify against your client because it's just going to boomerang. But your client will think about that.
Yeah,
and
client's
so it has
pissed
some
off sitting there. And
so it has some
doesn't want
benefit to the
questions.
defense to just cast that pall over it. Oh, my ex-husband will be coming in and he'll talk about the affair. And no, it's never going to happen. But it'll put that seed of thought in your client's mind, and they want to avoid that. That it's just, and those are just tactics. And like Maureen and Derek say, they get paid by the hour. Just because they ask a question doesn't mean there's an answer. Tell the client, just don't fill in spaces. Don't make stuff up.
Right. You're intimidated because you come in, you've never been in a deposition before. We've been through thousands of them. We hardly even look up when they start asking these stupid questions, and the client gets like angry, like, this has nothing to do with it. And I'm like, no, that's okay. Just answer the question. If you don't know, you don't know. Just don't make it up. That's the problem.
Yeah. Also, when I probe a client, I try not to be too stereotypical, but the first thing I look at in the file is the defense attorney's firm. Then I look at the area code. And if the area code is 845 or 518, then it's generally 716. It's generally okay. 315 generally goes well. Not always, but that's like the general rule. If the area code is 914, it's just going to be painful. 212, 516, 732. The New York City and Westchester depositions are generally a lot more time consuming, and those lawyers, they're not any better. It feels like they just run the clock on these. They just want to ask everything, and it's all about the billable hour. They want to make partner
at their firm. They got to bill these hours on these firms. That's how they're going to do it. So we should probably tell the podcast people what use it is for them. Besides the defense evaluating the type of client at a trial, you can use it to cross-examine and to really nail the defendant down when they say something wrong, because they'll take the paper out of your briefcase and you'll hold it in front of them, and then the look on the witness's face is usually priceless. Now here it comes.
Yeah, and a deposition, when you question the other side, it is in the nature of cross-examination. You can cross-examine the person. At trial, it can be extremely helpful to have the deposition read to the jury because the defendant was under oath, and you can encapsulate facts very simply about the accident and put that right out there. And sometimes what I've done at trial is that the defense will come up and say how they're defending the case, and the client's not really at fault. They're not sure what the color of the light was, but their client didn't run the red light. And then I get to ask the question, do you know what color the light was, and the person says no. I says, so do you know if it was green? They go, no. And now this is contrary to what the defendant has just told the jury, and you just read the transcript to the jury, and it's evidence. And then they look like they're trying to mislead, which they are. And but the transcript, the deposition locks in the story. It's really hard to change things at trial. Bad or good, whatever your client says in a deposition, you're pretty much stuck with it unless you have a really, really, really good explanation. And that's why it's important.
Also, the insurance lawyers take the transcript, and they'll do a summary for the insurance adjuster, who then evaluates the case. So if your client does a good job at their deposition, the lawyer and adjuster will both see that, and they'll look at the case as being of a higher value, as if they don't come across so well, even if the substance of their testimony is good. So their appearance, the way that they testify, along with the substance, are all factors in evaluating the case and putting a value on it. So it has a direct impact on the value of the case.
Yeah, and you're the one who went through this car crash, fall down, medical malpractice, whatever it was. You know how it affected you. And it is very hard sometimes to talk about all that pain and suffering that you had. And a lot of times people, even a car crash, you'll start talking about, people will start crying, talking at a deposition. And you have to try, I always reassure them and say, it's really probably good for you to get this out again. It's like a catharsis. You get this out and you remember how bad it was. And that's what I've tried to tell my client. That's what I want you to communicate to the defense attorney, that you're going to be able to tell a jury, this was not just like a little fender bender. This was a big car crash. Here are the photos to show it, and this is what's happened to me. It has changed my life dramatically. It's easy for me to rattle this stuff off, and I know it's difficult when it's happened to you. Sometimes we use the spouses or the adult children or people in the family who can come in and talk about how devastated this was, because all of these injuries that we're talking about, and we're making it sound very lightly, has an emotional component. It affects your life every day. You used to be able to take care of your kids, now you can't bend down. You used to be able to take care of the house, now you got to hire somebody. It affects you financially. These are really, serious events that we try to make the client understand. The jury has to be the one to feel the most about it, not just the defense attorney at the deposition.
Yeah.
And it's always really important to tell the truth. I had a deposition a couple of weeks ago in a case where the client, not to protect herself, but to protect some firemen who did a report on an oil spill, and they wanted to protect the homeowner and wrote down that it was just a few gallons when it was much, much, much more. But the official report of the fire company totally minimized the spill in order not to bring in the DEC to investigate and was doing the homeowner a favor. But meanwhile, it was contrary to what actually happened, that the oil was more than 120 gallons, and the fire department put down like 7.
Wow.
And the client had the opportunity to refute what was in the report by the fire department, and should have done so because it was not true, and didn't do it. And it is extremely harmful, bad or good. Sometimes the client does it not to protect themselves, but to protect others. But there's no exception. Tell the truth. Period. Yeah. Whatever you do, tell the truth or don't say anything, but don't lie. The lie is always 5 times worse than whatever the truth is. And it's hard to emphasize that because sometimes things seem to be minor, but they're not. They get blown out of proportion. The case becomes all about credibility rather than about who was at fault in the accident or what the nature and extent of the injury is. They make it credibility. And even though the statement may not reflect on the nature extent of damages, it does to the jury. And so it's always, without exception, tell the truth. That's
a basic.
Yeah.
You can't get away from that. And if you don't know, don't guess. This is what people think, oh, this person's asked me a question, they're wearing a suit and tie, I should know this answer. I was close by, I'll just say 15. I'm like, where did you come up with that number? I wasn't sure, but I just said it. I'm like, oh. So it is a problem.
Yeah, if the jury thinks that the plaintiff is lying, they most likely won't return a verdict in the plaintiff's favor, even if the evidence is in the plaintiff's favor. If the person is dishonest at trial or in their deposition, the case will usually be lost.
And sometimes it's so benign about like a previous injury or something that the person actually doesn't remember even something that happened, maybe a work-related incident
that does
years
happen.
before,
Yeah.
but then, and the defense has, of course, every record imaginable.
Right.
And they ask, and then when the client says, absolutely not, that never happened, and I just know, oh boy. And
Now they're going to
then
either show you the record that shows that you did have this motorcycle accident when you were 15 or 18 years old, and you're not remembering it now that you're 50 or 60, but it did occur. And don't panic. Just say, oh, okay, now I'm looking at a piece of paper. It reminds me it does. Sometimes you get your recollection refreshed.
And because that becomes the issue rather than who's at fault and what happened to you. The issue is credibility. And we always want to have credibility on our side and have the defense the ones who have questionable credibility. And about answering the question and going down the list, because the defense uses these frickin' checklists. And there'll be a question like,
Depends on your area code, is what Derek
are
was
you
saying.
married? Are you married? And the client says no. Next question: what's your husband's name? And it's like, huh? But and how can they be doing this? Simple. They're going down the checklist. Do you have any children? No. What are their names? And here we go. And they just keep going. And I always tell the client when they ask you that and you weren't married, don't think when you were like 6 years old in the backyard you're married to next door neighbor. That please just say no. And when they ask you the other question and follow up, just look like a deer in the headlights. Don't answer that. And they don't have anything that. They're just asking questions off a list, and they get paid to do it. They get paid by the word, by the question, and don't just fill in the blank, which sometimes clients do.
Yeah. If you don't know, don't guess, because if you guess wrong, then that's going to hurt the case. So if you guess, it's okay as long as you guess right.
Yeah, this is what I say. You get no points for guessing right. You get 50 off for guessing wrong. And because there's no benefit.
Yeah. I mean, and if you don't know, it's fine to say, I don't know. It's not a memory test.
It's okay.
So, the best answers to give, I tell people, are yes, if you can say yes, no, if you can say no, and I don't know if you truly don't know. Those are the best answers to give at a deposition. And, or keep it to one sentence. If you have to explain something, one sentence is the way to go. Except about your injuries and your pain and suffering.
Right, at the end of the case, when they're tired and want to get out of there and want to eat lunch and do a million other things.
When you're tired and hungry and you want to go home, it's time to give your longer answer about how your back hurts and your knee hurts and you can't play with your children and you can't go up and down stairs easily. You missed several months of work and go on and fill in the blanks there as well as you can, because if you don't, later on at trial, when you say all these things that you can't do, then the defense can take your transcript and say, well, when I asked you this question, didn't you only say 2 years ago,
I
you only
asked
said
what's wrong with you, and you said, oh, I'm pretty good, and now of course you can't go up and down the stairs. Now you remember it. It does become a bone of contention, a problem for the case. You have to think about what you're saying.
Yeah, sometimes you get in situations where it's a former employee, and they'll have the employer come in, and there's some reason some reason that had nothing to do with the case, but there was a dispute with the employer, and the employer then will just go on about how the person was a bad employee, et cetera, which oftentimes isn't true, but they might have contested an unemployment insurance claim. And now the defense has all this information, and they start asking the client about it. And the client, I just tell them, just answer truthfully. And it'll seem like the defense has this information and that it must be credible because it's in some report or writing, but it isn't necessarily true. And I just tell them, just always answer truthfully. Just because you're confronted with something that somebody said doesn't mean it's true. And you were there, just answer truthfully. And sometimes it's hard because sometimes the client wants to argue and explain things, and all that is digging a hole. Just answer truthfully, short, yes, no, don't know.
Well, in in state court, which is where we have most of our cases, the parties get deposed. So that's the plaintiff and the defendant. Those are the ones who are typically always deposed. Sometimes there's a non-party. If there was a witness, you might want to depose a witness.
Or an ex-employee, maybe they're not controlled by the defendant. We may have to subpoena them to come in and testify what they remember at a workplace location if that's where it happened.
Yeah. And sometimes it's easier to circumvent the deposition and just get a sworn statement from a non-party witness, which then you have the statement and the defense doesn't have that initially. You can always show them a copy later on. But that's a way to gather evidence without a deposition, which you're allowed to do that as long as it's a non-party. And in federal court, not state court, but federal court, the experts can be deposed, which would include doctors, or if you have engineers, some other kind of
experts. Yeah. It adds volumes to the case as far as costs and what's going on because they get compensated. However, if you do a good expert deposition, it often can resolve a case one way or the other.
Yeah.
Yeah, usually it's the defendant's advantage to have them depose your client, your expert, before trial. Then they come back loaded for bear at trial, and they get to take the transcript, research things, try and then, when the expert testifies at trial, catch him on a few things. So it's a little bit different. But the advantage also in federal court is you can use a deposition as trial testimony for parties, non-parties, experts. You can use them as evidence in chief. In state court, the only time you can use a deposition is if it's a party's deposition. So if it's a non-party that gets deposed, then you have to still bring that non-party into court. So most of the rules in federal court favor the defense. They're more favorable, if at all, to the plaintiff because you can marshal your evidence and prepare your case for trial. Whereas in federal court, it's almost like everything for trial is done before. And
right, you try the case completely. You know what they're going to say, you know what he's going to say, and then even when you're picking the jury in federal court, you get about 13 minutes to do so with the judge sitting there the whole time. So there's very little. It's a very rigid courtroom compared to our state courts. Anyhow, I always say that.
So we hope you enjoyed this episode of Upstate and Litigate about depositions. If you have any questions about depositions, you can always reach out to us at Basch Keegan and Spada. And if you click the link below, you can like us and subscribe. And hope to see you around.
We're not going to drag it out the way defense counsel does at a deposition. That's it. We're done.
That's a wrap. Less is better.
Yeah.